Actually.
Good evening.
Good evening.
You are live here at Courtside with Lawman,
And Carmen B.
and we are here to talk about legal issues that affect the public and the community.
Yes, we are. And we would like you to join into the discussion, give suggestions, have questions, and things like that. You can catch us on the chat. You can call a number, right, Carm?
You can call 916-443-5288 with your questions. You can post your questions in the chat.
And anything we say does not form an attorney client relationship with you and Carmen or myself.
That is correct. We are an informational and an educational program. We are here for the public. We want you to be informed.
And so that's why we exist. Now, tonight, we're going to talk a little bit about, as you saw, the title's kind of large because there are some new laws that are coming out that are going to affect sentencing and sentencing enhancements. So we're going to talk about that first, and then I'm going to talk a little bit about jury selection in the Arbery case and the Rittenhouse case and the issues that come up in such cases regarding jury selection.
We also would let you know that we're changing the format of the show slightly, and that is we previously had been doing the show for an hour. We are now only going to do the show for a half hour. We hope to be able to get to all of your questions during that time period.
Definitely.
Anything interesting happened this week with you, Lawman?
Oh, gosh. Yes. Besides being pissed and disappointed at a few people and things, I guess that's the nature of our game. Is that you win some, you lose more. Just feeling the effects of I should say the way that sentencing is done here in California, and on a case-by-case basis, really, every time a person is sentenced, it really shouldn't be compared to another. However, people do that all the time. They'll say, well, somebody else got something for a petty theft. Somebody else got something for shooting a person, and he's getting more for pushing a person. There's always going to be comparisons and stuff. And sometimes you get a little fed up with how that system really works. How sometimes the sentencing part is not fair. Sometimes the sentence that one person gets may not seem fair as compared to others. But it's something that you just have to fight and live through. It's been pretty busy this week, just trying to deal with cases and things like that. You got to get over the fact that you're not in control over anything, hardly, especially when it comes to receiving your discovery. That the DAs right now in Sacramento are complaining about having too many cases, that they have 300 cases and things like this. And so they don't want to give up discovery.
Well, let's be clear on that. You're going to get the initial discovery, which is the initial police report. But in terms of requesting additional discoveries, such as body cam footage,
right,
or dispatch logs, right, or CSI photographs, yeah, or video surveillance, there may be a delay in getting those things. There may be some of the district attorneys who are saying that they are not going to provide those things unless the case goes to preliminary hearing, yeah, or goes to trial. And unfortunately, that is within the law. The law only requires that they provide that discovery prior to trial. So in the pretrial or the initial actually negotiation stages, those items don't have to be provided. Now, Sacramento County, I have had some good luck with those items being provided because they sometimes help to negotiate, right, a case. They either help the client to see or help you to explain to the client why the case is, not good for defense, or it shows the weaknesses in a case that you can then point out to the district attorney and get a dismissal or a better offer for your client.
Right. So it's valuable in all cases. But, I try not to view just because we're busy Just because we have a lot of cases doesn't mean that we don't try to satisfy our discovery rules and things like that. Carm's right. But here's the other part of that. If that's the case, if they don't want to give us stuff until we go to trial, then we as the defense bar, what we should do? We set every case for trial right away. And then we'll start getting stuff. We'll start getting cooperation and things like that, because we will pound them into the sand, basically, because they will not be able to respond to such a thing. And they'll be dismissing cases and settling cases left and right. Sometimes it takes that kind of pressure on one side.
Well, that only works if everybody is willing to do that. One person doing that usually just ends up hurting potentially
one person,
the clients.
But you remember, Carm, when we started out, remember our mentors and our people over at the public defender's office, and what would happen if they had a disagreement is one of the supervisors would say, we're setting everything for trial. And then they do that for a couple of days, and then the dispute would automatically be taken care of. Because the higher ups and the judge will wonder, okay, what the heck's going on here? We got to solve this, or else all these cases going to trial. But the PD's office was not afraid to do such a thing, like set every case for trial.
Well, I don't know that it necessarily was a matter of fear. The public defenders has enough attorneys and carries enough of a caseload where them setting every case for trial will have an impact on the local criminal justice system, whereas one attorney doing that will not.
But that's what I'm saying, is that at least the public defender's office had the guts to do such a thing. That has not happened in 20 years or so, where the public defender's office has taken a stance and said, we are not going to stand for you giving enhancements that are not in the statute just because you want to do it, DA. And that's what they've been getting away with a lot. So when you have an accident in a DUI, when you have a high BAC in a DUI, when you have a refusal, they're asking for extra time. And I mean like 30 days, 40 days.
So and it's not statutory. It's not an actual enhancement. They're just increasing the time.
They're giving you a higher offer because there was an accident. It may not be an injury, just an accident. Because your BAC was 0.20. You didn't hit anything. You didn't do anything. You're just drunk. And they want more time because your BAC is 2.0 versus the person who might be 1.0. And that person 1.0 is the one who killed somebody. You see, so I'm going, wait a minute. Why are you jacking it up on people, you see, when they didn't kill anybody? Because in every negotiation, every DUI, guaranteed the defense not the defense, but the prosecutor or the judge is going to speak up at some point and say, well, they could have killed my grandma. They could have killed somebody. And that is true.
Well, we can't sentence people on what could have happened. We shouldn't be sentencing people on what could have happened.
My point. But they're getting extra time out of people, forcing them to plead to something instead of going to trial just because they don't want to take an extra 20 days.
Well, I'm going to disagree with you there. I'm not going to say that they're forcing someone to proceed to trial. They're not forced to proceed to trial. They're not forced to plead. They have the right to proceed to trial should they choose so.
However,
but a lot of times in those cases, they realize even though that offer carries the extra time, that if they proceed to trial, that's going to carry even more time. So I don't disagree with the fact that they are, your experience is that they are adding extra time on.
They are.
But no one is forced.
Carm, you've been doing this as long as me. Please go over to DUI court and come down just a little bit and go, what is this 30 days for high BAC?
I'm going to leave that up to you. I tend not to handle the DUIs. I send those your way. But let's start talking now about the issue with the changes that will be happening in terms of sentence enhancements and resentencing.
So tell us first, what is a sentence enhancement and why do people care about this?
Well, a sentence enhancement is something that is alleged in addition to the substantive crime that usually results in there being an additional punishment for that enhancement.
Okay.
So one example would be someone who has committed an assault could be charged with an enhancement for causing great bodily injury. If during that assault they also used a weapon, they could be charged with another enhancement for having used a weapon. And by weapon, we don't necessarily mean firearm. There could be an enhancement for using anything that is considered a
deadly weapon. Yeah. Okay. So, what are these enhancements like? I mean, is it like just a few extra days or years?
These enhancements normally carry years. So
More
the
than the target crime
GBI,
sometimes, right?
sometimes. So the GBI carries an additional 3 years on top of whatever the substantive crime carries. Um, Gun enhancements. Those, there was the gun enhancements that got passed that we've talked about before, and they probably initially started now. I don't know, when was that? Maybe
Oh
20,
gosh, it was
20
years.
years
Yeah.
ago, 15, 20.
10, 20 life. And
Yes, and it was the 10, 20 life
use a gun, go to
enhancements.
prison.
Use a gun. That doesn't mean discharge the gun, but use a gun during a certain list of specified crimes. A 10-year enhancement is added.
Right.
Discharge that gun. Not hit anyone, not strike anyone. The bullet doesn't have to strike anyone. No one has to be injured. 20-year enhancement. Actually have that bullet hit someone.
25 to life.
25 to life. Doesn't matter that it just grazed them, that they're still, that they survived it. It still is a 25 to life enhancement. So the governor has signed into law now what started as SB 81, sentencing and dismissal of enhancements. And this basically amends Penal Code Section 1385 to allow the judge more discretion and gives him specific circumstances that he can or factors that he can consider in determining whether or not to dismiss, or what we refer to as strike an enhancement, meaning take that enhancement away so that there won't be any additional time imposed.
Well, what is when you say 1385, what do you mean by that?
Penal Code Section 1385.
What does it allow a judge to do?
It allows a judge, it gives a judge discretion in terms of dismissing enhancements, but there were certain enhancements that the judge was prohibited from considering to strike. Now, we did have SB 620, which then did give, and that again gave the judge discretion to strike gun enhancements. So one of the things that the court, that it lists specifically that the court can consider and afford great weight is the language to evidence offered by the defense to prove that any of the mitigating circumstances in the subparagraphs are present, any one of them or more than one. And those include if there are if the enhancement results in a discriminatory racial impact. Now, it's going to be interesting to see how that is applied, because we know from experience that we see discrimination in our criminal justice system.
And when it says discriminating racial impact,
it specifically
on
says
society or just one person,
as described in paragraph 4 of subdivision A of section 745, which is the new section regarding racial discrimination in the criminal justice system. Again, because it is new, both of these are new, it's going to take some time to work out how and what has to be shown to prove that discrimination exists.
Because think about that. I mean, usually we're not trying to show that there's racial discrimination. In fact, you're usually precluded from doing so. I mean, so now when the new law came out, when 745 came out, now you can, if you have facts to show that there's some racially discriminatory issues regarding your case, you can bring those out. Right? I mean, you can do that now.
Well, this is specifically, I'm talking specifically as to what the judge considers, not related to anything else.
But what I mean is that the judge considers, you said, the racial discrimination
impact.
Right.
So, for example, if you can show, my argument would be that if you could show that African American men that the gun enhancement is imposed on them at a higher rate than other people committing that same crime and using firearms, that would be an example.
So we need somebody to do some studies.
Those things certainly do need to occur.
Okay.
Other considerations are, and I remember we're on a short time crunch. If we're gonna reduce the show to 30 minutes, I want to be able to get through this.
I didn't think we were doing it this time, but okay.
The application of the enhancement could result in a sentence of more than 20 years. In that circumstance, the enhancement shall be dismissed. That means it is not discretionary. The court shall dismiss that enhancement. If there are multiple enhancements alleged in a single case, all enhancements beyond a single enhancement shall be dismissed.
So basically,
if the current offense is connected to mental illness, if the current offense is connected to prior victimization or childhood trauma, if the current offense is not a violent felony. And I want to be clear, it sounds like this can apply to violent felonies, but this is just one factor that the court can consider.
Right.
Additionally, if the defendant was a juvenile when they committed the offense, or if they were a juvenile at the time that they committed any crime that triggers the enhancement. So to me, that may help us in terms of clients who are charged with juvenile strike priors.
Now, yes, when they're going to be used against them. Yes.
Additionally, if the enhancement is based on a prior conviction that is over 5 years old, and additionally, although a firearm was used in the current offense, it was either inoperable or it was unloaded. Now, I would note that those are just the circumstances that are listed. The law specifically says that those circumstances are not exclusive, and the court maintains authority to dismiss or strike an enhancement in accordance with subdivision A. So even if one of those factors does not apply, the court still has authority to find a basis for striking the enhancement. Now, I will note that the court can find that if dismissal of the enhancement endangers the public safety, then they will not dismiss that enhancement. And then one other important factor is that this subdivision applies to sentences that occur after the effective date of the act that added this subdivision.
Right.
So that means it's not going to be retroactive to, unfortunately,
anyone,
all of the young men who are already sentenced, who are already sentenced and serving this time. Now, if they are on appeal, there may be an argument.
Yes. Well, in re Estrada always saves you if your case is not closed.
If it's not final.
Final, right.
Yes.
Now, here's a question, and I think Marianne has said, and this is one enhancement. How does this affect gang-related cases? Because is there a gang enhancement that it can affect?
There is a gang enhancement, so it would apply to the gang enhancement as well, meaning that the court could decide to strike the gang enhancement, especially, again, because we do see racial discrimination where that gang enhancement is used.
And, and there's another case, I'll look it up again, that just came out that talked about gang enhancements and the things that now a court can do to actually sustain them better. So we'll see how this really works. I think the point is this. We have a new law. It doesn't come out just yet. It probably is going to start at the beginning of the year, hopefully. Now, that new law gives the judge a little bit more leeway when there is racially discriminatory information regarding the case. A lawyer can make an argument with all those things that Carmen said, that the mentally illness is connected to the case, anything like that. You can make those arguments and ask the court to use its discretion to strike these enhancements. And remember, enhancements can be great bodily injury. Enhancements can even be hit and run, leaving a scene. Enhancement can be for gang activity or being a member of a gang and trying to promote a gang in that crime. It can also be for guns. Enhancement can be for a monetary loss. So there are several ways of getting enhancements on your sentence. Now, and what they're trying to do is, I think what they're trying to do is allow the court now to start litigating these issues. Before, you weren't able to litigate these issues. So now what they're doing is trying to litigate these issues in the trial court so that it doesn't get more appeals and they serve less time, which is the federal court order, to try to keep as many people out of prison as possible.
I don't want to confuse our viewers. The court can actually do this at sentencing. The court can do it before, during, or after trial, or at the time of entry of plea. So it's not just a case that has proceeded to trial. The court can exercise this discretion at almost any point of the proceeding.
And we are hoping that we're not stopped by the inability to show racial discrimination in your case. Whenever I hear about racial discrimination in the law, I always have to go back to the death penalty and how the death penalty was applied tremendously more to African Americans than anyone else.
And still is.
Yes, McCloskey, I think it was. But the court said, yeah, we understand that. We know that. But you have to show that your client in this case was racially discriminated against by them seeking the death penalty. And since that is the prosecutor's decision based on whether there's capital murder or not, which capital murder is first-degree murder, it's very difficult to say that their motivation was racial discrimination in filing the charges if, in fact, they are alleging a person killed another person. So there's always been the knowledge of the court that, yeah, racial discrimination, obviously it goes on and all that, but you know what? You got to prove it in this particular case. And here, I'm just hoping that battle is not that tough, but I get a feeling that that's exactly what you're going to probably have to do.
I don't think that is the case. I think I think based on 745, it's showing that there has been a pattern of racial discrimination. So I do not believe that it is going to require that you show specific discrimination against your client. It's discrimination against that group of people as a whole. But we do need to move on because there is another sentencing. Go ahead.
Yes. If it's no. My last point is this. I dig what you're saying. Okay, but here's the thing. Do I really got to go out and prove that? I mean, is that something that I got to go out and individually prove?
Well, again, as you say, there will have to be research studies done that will show. Right. Anecdotally, we can show that there has been racial discrimination. Yes. But let's move on because we want to be able to cover all the topics that we need to cover in the short time period that we have. There was also signed SB 483 sentencing, which is resentencing to remove sentencing enhancements. Now, this is not all enhancements. This applies specifically to sentence enhancements related to controlled substances. So there were 1 year and 3 year sentence enhancements that people could receive for having drug convictions. So if you had a client who had a prior conviction for selling drugs and was arrested again for selling drugs, he now gets an additional 3 years added to the new sentence because of the fact that he had a prior conviction. Clients would see that as, oh my goodness, I've already been punished for that. Right. I served my time. Why am I being punished again? But the law did allow that. That is now no longer the law. Not only is it no longer the law, but specifically, if there are people who are serving time for that, CDCR is supposed to contact the courts, notify them so that they can remove those enhancements because those enhancements are now illegal. Now, we know that CDCR may be working as hard as they possibly can for this to occur, and there may be people that they miss. So if you have loved ones who are serving prison sentences related to drug crimes, you want to have them, they can write in themselves to the court to ask for resentencing under this code section.
Definitely under the new law.
And you also can contact an attorney. You can contact Lawman at
443-5600 or Carmen
at 916-443-5288. We don't want people serving sentences that they should not be serving based on the new law. And again, I'm sure CDCR is trying its best to get those people back into court, to get them resentenced, to get those sentence enhancements removed. Again, it is not all sentence enhancements. It is those specifically related to drug crimes, controlled substances.
And I'm pretty sure
3-year enhancements.
1 year prison priors, right?
Yes.
Okay.
Yes.
And I'm pretty sure that the legislation was motivated by more and more people now with the opioid process and selling opioids and selling drugs and things like that. I'm pretty sure they were motivated. More and more people.
More and more different people
being in the drug scene
and the people that have been
normally have been there
harshly for years and years and years.
Like Eldridge Cleaver with a marijuana cigarette getting 3 years. That's kind of harsh. Now that we look back at something like that.
Well, especially now that marijuana industry is $1 billion business.
That's right. And she said, we can call her Sean. But she brings up my point too, is how can you prove racial discrimination in your case? I mean,
and again, it's not going to be in the specific case. What it's going to do is be based on the group that your client is a part of, and how we believe. And again, because the law is new, we're not quite sure how it's going to operate, but how we believe that it may be proved is through research and statistics that show, hey, wait a minute, the African-American male population of Sacramento is only this percent. And then there's this percent of them who are arrested for crimes. Of that small percentage, there is this huge number who are hit with these enhancements. Whereas there are these other groups committing the exact same crime who are not being given these enhancements.
And it is a point of fact that we are being stopped far more times.
We're seeing that,
all around the country. They're determining that. Now, should we now see? And that's what I mean.
For our numbers in the population, we make up 12 or 13% of the national population. But you're seeing in places we're making up, 40%, 30% of the traffic stops. Well, how can that be when our numbers are so small? We are not the majority of people who are driving.
Right.
Unless somehow we're the only ones committing traffic violations, and I find that to be doubtful.
No, and that's why, in a way, I'm disappointed, because they're telling me, hey, okay, if you can find some racial discrimination and stuff, then maybe the law can help you. And I'm going, wow, we had to really come out and say, let's look for some discrimination before the law is going to help me. And
when we already know that the discrimination is there and that it exists.
So why do we have to go prove it? How do you go prove it? I'm telling you, we're going to have to get some psychologists, and Dr. Joy DeGrow. I've always said she'd be perfect for this because she did the post-traumatic slave syndrome thing. She could bring that in. She could bring in the stats about the stops and the number of prosecutions. And then, hey, Black people are being racially discriminated against. Therefore, take the enhancement off of this guy's sentence. You see, take the enhancements off of these guys' sentences. And that's what technically would happen. That's how that could happen. So we don't know how it's going to work just yet. But I said that I'd talk a little bit about jury selection in the Arbery and Rittenhaus cases. So just give me a minute or two. Just want to mention, if you're watching that trial, please watch it. Watch them both if they're on TV to watch. The judge in the Arbery trial, they just recently selected their jury, pointed out that he felt that Black people were being kept off the jury. Now, he is the person to go to in order to complain about it, the judge in the trial. But the Batson-Wheeler type of analysis is this. You can't kick anyone off merely because of their race. If you have other reasons to kick them off and you can articulate those, then a judge can find that you didn't remove them simply because of their race. Prosecutors all over are being taught, trained how to, through questioning, disqualify us because we have a tendency to go, yeah, we think police are a little bit unfair to us. Yeah, I've had an experience in my family, or I've had my experiences with officers that have been bad. Once we say something like that, prosecutors now can go, aha, that person's biased, or at least they may be biased to the system because of what has happened to them. And that gives them justification all day long to kick the person off.
But it's a catch-22 because we are contacted and arrested and prosecuted at higher
discriminated
numbers.
Against.
You're going to have higher numbers of us who either have had an experience or have a family member, a relative, a cousin, a brother, a sister who has had an experience with the criminal justice system. And those are the kinds of things that are used to kick African Americans off the jury.
And so I'm going to tell you something, all right? This is coming from the heart. And tell everybody, look, if you can serve jury duty, and you can, even if you're a felon now, okay? Register your car, register to vote, get on a jury. The thing that you have to do is you have to discuss issues that you have. But you never say,
You have to remain fair.
Yeah.
And that's all. You have to, despite whatever the issues that you have had, you have to
doesn't bother you.
Fair.
It doesn't bother you. You're okay with it. You can remain fair. You don't hate cops. You don't hate the system. In fact, you're a great citizen and you just want to participate in this system. You got to say things like that. You see? You may be that deep down, y'all could feel that, hey, this is a terrible system and all that.
We do have a question that was texted in. Okay. And the question is, does the Batson-Wheeler motion apply to defense attorneys, or is it just for the prosecution? No, it applies to
defense attorneys too.
In fact, I can recall one time
somebody as a defense attorney because you kicked off all the Asians. I bet.
No, they said that I was. They said that I was kicking off. I believe they said that I was kicking off all of the white women, and I was leaving on African American men and white men.
Gender.
It was their motion was denied. The judge found that was not what I was doing, and there were specific, legitimate reasons for me having kicked the jurors that I did request not be allowed to.
So yes, defense lawyers have to be careful too. Just picking off a certain race, a certain gender. Basically.
But we've seen things happen that are fantastical when it comes to the rationales that they will give. There was a potential juror who was clearly an African-American person who had a very African-American sounding name. In fact, before she ever even made it into the box, I had looked at her name and said, this is probably an African-American person. Mm-hmm. And the district attorney kicked her. And the reason that she gave for kicking her was that she had on casual attire and she had on what would be workout clothes. Well, I pointed out that, hold on, there were 3 other people on this jury, this potential jurors, who were also wearing workout attire, and she did not exercise her challenge. We say kick off, but we really don't have the ability to kick anybody off. We challenge them. The court makes the final decision as to whether they
except for peremptory challenges.
Yes.
Now. Okay. We can kick somebody off.
Yes.
We can deal with that one because that's exactly what we're talking about. We tend to tell the truth about things when we're there. And I'm not saying lie under oath.
You're required to tell the truth.
I'm just saying that you have got to couch your answers.
Maintain your ability to be
fair. Right.
Maintain your ability to be fair.
Cops put me in jail for 20 years and stuff. I came out and sued them, but I can be fair. You see, that's
and the comment was, God-fearing, law-abiding, second-class citizens in America have been taught to tell the truth. So in voir dire and jury selection, they disqualify themselves by truth.
Right. If you get up and tell the actual truth, and here's the thing. It's not like you're lying, but what you have to do is answer the question. And all questions are geared towards, are you biased? is there anything about you that's going to show bias one way or the other to the defense or to the prosecution? And that goes for everybody.
And we want jurors who are not biased for either side. And that is how we reach the ideals that we are trying for in our criminal justice system, is by having people who are truly going to listen to both sides,
Right.
and listen to evidence presented by both sides and follow the law.
Withhold any judgment until the end. That is
and
also
hold the prosecution to
the
that
burden.
high burden of proof. Don't
Yes.
lower it because the person who's seated in the chair looks different than you.
Right. Wear a different hairstyle and stuff like that. So the issue of Black people on the jury is huge. I mean, I've done 180 probably jury trials. The most Black people I've ever seen or had on a jury, I think, was about 4.
Oh.
Yeah.
Well,
I mean, that's
go.
one jury. Okay. That's one jury out of that.
There you go.
Other than that, it's been 2,
One.
You get lucky.
Yeah. It's one.
Yeah.
It's none. A lot of times
none.
It's absolutely none.
Yep.
And so you have to explain to your client that jury of your peers doesn't mean people who look like you or who are of your same age
experience.
group. It means of your people from the community, the city that you live in.
Right. So.
All right. So now you were going to talk a little bit more about the.
Well, in those cases,
we're going to exceed our 30 minutes, but I'm going to allow Lawman to do it because he has some important things to say.
Look, I'm just talking about in those juries. What's happening is the Black population in the town, maybe 40-50%, but there's one person that might get on that jury. Now, a lot of times we keep ourselves off the jury because we don't register to vote. Or we don't register vehicles, okay?
Or get your license. Make sure that you have your driver's license. Right. Or if you can't get your driver's license, that you have your identification card.
Right. Because you want to be on that panel. You a lot of people are trying to get off jury duty. But man, there is no work more important than serving here.
Yes, you can't complain about what the system does to your community if you're not willing to participate in these important things that we need citizens to do. And one of those is jury duty. And
now that felons can be on a jury, man, you see, now it's beautiful because they're going to they can't kick you off because you're a felon.
And we have a comment from Sean. If we are being honest, selection of jury is a type of profiling.
Sure.
Yes.
Exactly. I mean, you want people who you believe will assist your case, who might believe in your case, who may have definitely some sympathy towards your position.
But they are specifically told that they are not to have sympathy.
Right.
They're not to consider the sentence.
Bias,
they are
sympathy.
Supposed to listen to the evidence and apply the law.
And make a decision.
Hold that prosecutor to that burden of proof beyond a reasonable doubt. That is what we're asking. Yes. That is what can prevent innocent people from being convicted. And I can't tell you the number of times that I've had cases where at first glance, looking at the evidence, it looks like the client did it. And with a little bit of research, a little bit of investigation, a little bit of digging, you that they did not. Whether it's via video surveillance or
witnesses
proof of
who didn't say what somebody reported they said.
Or proof with a receipt that they were somewhere else at the time that the supposed event happened. Or just the fact that some of the witnesses have a bias and are lying or mistaken about what they have seen.
Exactly. So, the point is we as citizens have to put ourselves on the jury. Okay. So, when you're there, you answer truthfully and, you show that you're not biased and you may make it on that jury. So those 2 trials, though, are ones to be watched because they are going to really, really decide how we view race in America, especially Arbery. Okay. The motive behind what happened there. The motive behind Rittenhouse, look, if he was protecting property, And people say, hey, he's trying to protect these people, property, and things like that. Well, believe it or not, the law says you can't use deadly force to protect property.
You cannot.
So he's wrong right out the box if that's going to be his argument, that, I'm protecting my friend's property by shooting people. So, we really are going to see what happens here. It's funny because usually it's OJ, it's Michael Jackson, right? It's those celebrities who get trials like this. And here we have ordinary average individuals now who are in these trials of the century. So if you watch them, come back on a Friday and ask us some questions about what happened. Maybe we'll probably try to talk about that in the next couple of times. What do you think, Carm?
Of course.
All right. Well, since we're going to end early this evening.
We're not just ending early. We are changing the format of the show. So for the future, it will be a half-hour show. We will still start at 6 p.m., but we will end the show by 6:30 p.m.
Yes. And still give us questions in advance to discuss, subject matters to discuss, and we'll do it.
Yes.
Because we're all about education. That's what it's all about. If we can teach you things, if we can inform you and enlighten you and inspire you, then we've done our job. So we thank you for hanging out with us.
We do.
Courtside with
Lawman
and Carmen B.
All right. Have a good evening, everyone.
You guys take care. Stay safe.
Thank
Please
you.
Stay safe.